Good evening to all present, respected deans, program heads, senior faculty members, colleagues, staff, and my dear students. We School Institution Innovation Council team is delighted to have you here for a session on IPR under the aegis of National IP Awareness Mission. Today's session has been specially curated and jointly curated and organized by the Ministry of Education's Innovation Cell, MIC, AICTE, DPIIT, which is a Directorate for Promotion of Industry and Internal Trade, Indian Patent Office, and B School. Now, as all of you are aware that IP Literacy Week celebration is on, and on 26th April, all of us faculty members and students, we undertook a virtual IP pledge. Yeah, remember? To be innovative and creative in professional life, as well as a pledge to respect the innovation, creativity, and intellectual property rights of others. Under the able stewardship of our group director, Professor Dr. Uday Sanuke sir, Institution Innovation Council at V School has been rolling out a range of initiatives to bolster innovation, entrepreneurship, and IPR at the Institute. And today's event is one of those initiatives, and it's been specially curated to enhance your awareness of IPR, especially in academic world. Now, IPR significance is widely recognized in business world as well as academic world because it gives a competitive edge in business world and protects your IP or intangible assets from hackers and pirates. India is a fast growing economy, and the government mission of making India a 5 trillion uh, economy requires us to pay a lot of attention on innovation. And as a corollary, innovation has become a bigger priority for Indian firms as well as government, and innovation needs protection. And therein lies the significance of IPR. Today, so without any further ado, let me now introduce our esteemed guest speaker for the day. It's a privilege and an honor to introduce our esteemed speaker, Mr. M.L. Mokashi. Sir is an Assistant Controller of Patents and Design at the Patent Office, Mumbai, DPIIT, Ministry of Commerce and Industry, Government of India. His earlier stints include he was a professor of intellectual property at Institute of Chemical Technology. He has also been examiner of patents and design at Ministry of Commerce and Industry, Government of India. Sir's impressive educational pedigree includes degrees in technical field as well as law. He has a BTech in chemical engineering and an MTech in chemical engineering from UDCT and an LLB from the University of Mumbai. Sir has delivered lectures at ICT Mumbai, Hafkin Institute, Government Institute of Forensic Science, Nagpur, UDCT, and Amravati. Thank you so much, sir, for acceptance of our invite. May I now invite you, sir, on the dais? And may I also invite uh, Dean Inovi, Dr. Kaustubh Daragalkar, sir, to please come onto the stage and present a token of appreciation to our esteemed guests. Sir, if you could please. So as a token of appreciation, we are presenting a Varli painting to you. And this has significance because Varli painting, as all of you may know, is tribal art, but it also enjoys an IPR, a geographical indication. Thank you so much. So the PPTs have been uploaded.
Okay. Thank you, everybody. So, you might be knowing that the world-based technologies, these are still not available to Indians because we are Indians. Okay. So, now we have taken up a chance to be a 5 trillion economy. So, IPR will be one of the important sections for 5 trillion economy. So I will just start. So actually, ma'am has already made a and given my introduction. I'll skip that. Okay. So what happened nowadays? Publish and perish versus patent, publish and cherish. What do you mean by that? So what happened? Many faculties and many research institute, they will just publish their research paper. Okay. And will be having just honor that I have 5 research paper in international journal. But many foreign companies, what will be they will be doing? They will copy that invention. They will commercialize it. Okay. And manufacture for their own, and same technology, same product will be exporting to India. So who is at fault? We or our system? So this concept was proposed by Professor Mashelkar, R.A. Mashelkar, who might be knowing that. Was it Professor Mashelkar, ex-DG CSR? Okay, CSR is a scientific and technological organization of Government of India. Okay, so that concept was given by him. Like if you are going to publish your only research paper, what will be the next stage? You will be perish. Okay, the same product which has been invented by you, okay, that will be exported to your country. For example, in olden days, actually, we were the largest cotton producer. Okay, and that cotton were used to go to UK, United Kingdom, and that cloth was exported to India, means imported to India. Okay, so who has at fault at that time? That government at that time. Okay, so similarly, okay, it is happening in technological field also. That's why it is said that the many world-based technologies are not available to Indians because of we are Indians. So opposite that, if we can patent it or protect your intellectual property, generated intellectual property by way of filing patents, by way of registering design, by way of registering copyright, then what happens? Even though you can, thereafter you can file the go for the research publication. Okay, because of that commercialization of that intellectual property, you can have many monetary gains. Okay, that's why we can say that patent, publish, and then cherish. So, what is the concept of property? It is similar to the other properties, immovable properties, movable properties. But patent, trademarks, design, these are intangible properties. Intangible properties. Okay, that's why it is an intellectual property created out of brain. Okay, your mind. So, for the sake of understanding, what is right? Right is a permission to do something or entitlement to do specific service and treatment. That is the definition. And property can have multiple rights. Okay. So, what are the rights over property? It is similar to the actual property. Okay, like a farm, like your house. Intellectual property is also one of the property. So, which are these properties? That is, you can possess it. Intellectual property can be possessed. You can alienate it. You can have ownership, usage, application, right to exclude non owners. This is very important. This right is very important. It has been used in copyright, extensively used in patent also. Okay. So right to enjoyment, right to have the transfer in others' name also. Okay. Right to control also. Okay. These rights will be with the property. Similarly, you can have these rights over the intellectual property also. So why intellectual property management, actually I am saying here management is important. Considering the academic institute, we have to manage our intellectual property because there is a global competition. Okay, high innovation risks are there. I think this is one of the topic of the management also, risk management. Then short product cycle. Any product has been developed. We cannot say how much time it will take for total distribution, and another product will be there in market for the same field. Okay. So need for rapid changes in technology also. Okay. Thereafter, high investment in R&D. Normally, I will say that the developed countries will spend near about 60 to 70% of total of their investment for the product development. Okay. And only 30% will be spent on marketing, taking that product to the public at large. But in India, it is reverse. Okay. Only 20% will be spent on R&D and taking that product in actual form, and near about 80% will be spent on the marketing. Okay, that is also one of the lacuna. So production and marketing is also problem. Need for highly skilled human resource. I was discussing with your director, like how we can marry the three fields in one. For protection of intellectual property, we need specialists from law field, specialists from technology field also, and specialists from management also. Okay, that's why we can create and protect better management for intellectual property. So need for IP policy, why it is uh, necessary to protect IP policy, and why there is a need for IP policy in academics, specifically for universities and R&D institutes. Because nowadays we know that government just provide the finance or funds only for the salaries of the faculty members. Okay, that's why there is an inadequate funding from the government. Second one, low pay in universities and research institutes. Okay, suppose right now there is an advertisement from the ICT for the professor of oil technologies. Okay, it is very specific. Okay, but similar kind of people will be in the industry. They don't want to come to the academic institute. Okay, they might be getting more packages, salary packages, but they don't want to come to the institute for teaching. That is also there. The low pay in universities and R&D institute, significant contribution in national development. Because of that, it is providing very less contribution in national development also. Okay, low university industry interaction, that might not be true for this institute, but there are other many institutes, R&D institutes also, and universities also. They don't have interaction with the industry. Okay, so another thing is that inadequate infrastructure and facilities for R&D activities. You need the space, you need the money, you need time also, you need resources also, you need human resources also to carry out the R&D activities. Okay, that's why intellectual property is management is important, and IPR policy are needed for that. So because of commercialization of your intellectual property, who is gaining? Okay, who will be gaining because of the generation of intellectual property and commercialization of that intellectual property? Mostly universities and R&D institutes, researcher, inventors, inventors research group also, and thereafter research assistants, students, postgraduate, guest researcher will be there, sponsorer will be there, and technology transfer unit. This is also one of the important technology transfer. Means one technology has been generated, one technology has been created in one institute. Okay, we need to have technology transfer offices. technology transfer offices also in that academic institute. So because of that commercialization, the National Patent Office also will be gaining government and public at large. So what are the objectives of intellectual property management? Creation of an environment that encourages, expedites the dissemination of discoveries, your invention, creation, new knowledges generated by researcher for the greatest public benefit. That is one of the objective. Okay. Second one, protection of traditional rights of scholars to control the products of their scholarly work. Suppose any student has generated intellectual property, like by filing the patent or filing the design application or by filing the copyrighted material. Okay. Actually, in case of copyrighted material, it will be generated, rights will be created automatically. So one should be there to recognize that. That's why the intellectual property management is important. So another objective is distribution of commercial results. Okay, like suppose one patent has been filed and it has been granted in the institute. If because of that commercialization, how will be their share of institute? Whether that money will be going to the management, whether some money will be going to the student, whether some money will be going to the technology transfer offices also. So that has to be decided under IPR policy only. So efficient and timely process of technology transfer by making product available to public at large. One of this objective is very important because if someone has invented something and if it is not right timely distributed to public at large, if it is not taken to market, I will say in your term, okay, there will be no use. So it is better to take that product in timely manner to the public at large, means in the market. So another objective is promotion, preservation, encouragement of and assistance to scientific investigation. What happened because of commercialization, the money coming to you as a royalty will be again invested to the research and development and marketing activities also. Another establishment of standards for determining the rights, obligation of university or R&D institute and creators of intellectual property and their sponsor with respect to innovation and discoveries and work created at the institute. So there will be a proper management at your institute for commercialization or generation of intellectual property. So these are the some of objectives. They might be overlapping, but they have somewhat different aspects also. So what is covered under intellectual property management? So patents, industrial designs, copyright, geographical indications, trade and service marks, plant varieties, and trade secrets. These will be covered under intellectual property management. So what is a patent? We'll take it in the another slide also. Patent is an exclusive right granted for an invention, for a product or process. Protection is granted for limited period. Means monopoly cannot be granted for unlimited time. It will be granted under the Patent Act. It will be granted only for 20 years. Okay. So what are these rights? What is the nature of these rights? These rights will be territorial. Means patent is granted, then that patent will be enforceable only in India. It will not be enforceable in US. Many applicants say that my product has been patented in US. Whether same patent has been filed in India or not, that has to be found out. Okay. If that patent has been applied in India also, then only it can be enforceable. There would be no infringement. You can utilize that technology freely in India. Okay. But because of that, we are under US USTR, I think, United States regulation under that supervision. Okay. So Which type of right will be there? Like right to make, right to use, right to distribute, right to sell that product, patented product, or product made by patented process on commercial scale. Okay, commercial scale is different, and for purpose of R&D is different. You can utilize that product, patented product, without asking, without taking permission from the inventor, for research purpose only, academic purpose only. But if you want to utilize it for the commercial scale, industrial scale, you need to take permission, you need to take license. So what is industrial design? Design the ornamental or aesthetic appearance of an article. Means you can file the design application for that. So three-dimensional features of an article, two-dimensional features such as patterns, lines, or colors also can be protected under design act. So trademarks, very well known. So for what trademark is applied? It will be applied, the trademark will be applied for distinctive sign that signifies the certain goods or services also. So goods and services, exclusive right to use one or more words, letters, combinations will be there. So we have a lot of examples here: Tata, Pfizer, Reliance, DuPont, Cadbury, ArcelorMittal. Okay, these are the examples. So what is a copyright? Copyright right given to creator for their literary and artistic work like novels, poems, plays, a reference work, newspaper, computer programs, databases, films. The term of copyright is up to 60 years after the death of creator and varies from case to case basis. Okay. So copyright, I think it is more. You may be more interested in copyrighted work. So trade secrets. What is a trade secrets? Trade secrets consist of confidential data, information, or uh, compilations used for research or business, commerce, or industry. So that is the trade secrets. Trade secrets is protected under General Contract Act only. Okay, there is nothing like a special act to protect trade secrets. And one of the example is for Coca-Cola, secret formula of Coca-Cola. So new plant varieties will be there. I think you might be interested for the genetically modified plants. Okay, so these can also be protected, and plant breeders' rights. Suppose any new variety, okay, has been created, that can also be protected under New Plant Varieties Act. So, which are the relevant agreements for protection specifically can be taken up by the research institute or academic institute? We can have participation agreement. Okay, participation agreement that is related to the acceptances of policy by the employees, student, and guest researcher. Okay, earlier I had when I was in ICT as a faculty member, so I had suggested that you just place one page para like that all the inventions created in that institute or during the course of that institute will belong to that institute only. Okay, that kind of suggestion was there, but I don't know later what happened. The service agreement is there, like for the contract between the university and university or R&D institute and the company. Something has to be tested. Then there should be a contract, that is service agreement. Then material transfer agreement. Suppose you have developed one prototype and you want to send that prototype to any other institute or private company. There must be material transfer agreement also. Okay. So that is also important. Confidentiality agreement. This is general agreement. Okay, mean to prevent any unauthorized person from using the information without permission. So these four agreements are very important. So all these points are very important to you because you are the management students. Okay, like does that technology? Suppose you are evaluating any technology for the market evaluation, okay, and licensing. Does that technology offers you a cheaper and a better way to accomplish something? That has to be analyzed as a management student. Are there competing technologies available? And if so, how much better is the invention, your invention? Okay. Does the invention provides technological answer to existing problem? If there is a problem with that product, your product, whether it can provide a new solution to that existing problem. Okay. So again, does it have a potential for creating a new market? This question must be asked by the management student for marketing. Okay. So how much investment in both time, money will be required to bring invention to the marketplace? Similarly, will the inventor continues to work? Okay, sometimes what happens, the inventors are spending time and money also, but there is no market. So it will be quite difficult for him also. Okay, what will be the potential payoff for a company that makes an investment in the development of invention? So these kind of question must be asked. So other forms of protecting intellectual property are like these are the Protection of Plant Varieties and Farmers' Right Act, Geographical Indication Act, Semiconductor Act, Biological Diversity Act, okay, and then Information Technology Act. These are very important for protection of intellectual property. So I will just can I exit this slide next? I don't know. Want to close the? Yeah. So I will take another set of slides actually. If you think that these are not important, let me know. Okay, I will just skip because these are near about 107. Okay. So now we have already made that point like what is intellectual property, patent, design, trademark. So in a single product, I have already discussed with sir also that single product can have multiple angle for protection of intellectual property. Like in a single product, like Apple laptop, the LED display can have patent. Okay, body shape can be registered or protected under Design Act. Okay, and thereafter the Apple sign may have been protected under the Trademark Act. Okay, so thereafter the user manual or the software will be protected under Copyright Act. The layout and of integrated circuit will be protected under uh, Integrated Circuit Design Act. So a single product can have multiple direction for protection. Okay, so you have to think in that direction also. So what happened? Intellectual property is like it is created because of your mind, through your mind. Okay, so if you are using the resources, suppose you have only idea in your mind, okay, and then you are coming to patent office, I want to patent that idea, so that will not happen. Okay, you have to utilize your resources and you have to spend some time. Okay, then only that intellectual property will be created. You cannot have protection for only idea in your mind. So importance and significance of commercialization. If you are going to protect intellectual property, Because of protection of that property, you can exclude the others. You can have monopoly. Okay. Because of that, what will happen? You can utilize that, utilize and commercialize that product, specific product, and you can earn the money. These are all are interrelated. Okay. So utilization and commercialization. How the utilization and commercialization happen? You can use for your own use. Okay. Then either you can license or assign your intellectual property to other firm. Either you can franchise on your own, either you can merchandise. Okay, these are four ways to earn the money from protection of intellectual property. So for the common persons, like protection of intellectual property, like it's like a pride. For academic purpose also, uh, you can have research paper. It is the patent publication or design publication will have equivalent weightage as equal to the research paper. So, but as if you are thinking like a businessman, a businesswoman, okay, so one will think to earn and invest in that product, in that specific technology, which has been protected under the various intellectual properties act. Okay, so because of that, brand value will be created, and because of that, commercialization will go and go on. Okay, and in returns, he can invest. That businessman can invest in R&D also. Okay, so now we'll take what is a patent. It's so vast and more technical. What is patent? Patent is granted by sovereign state. Okay, US cannot grant patent in India, or India cannot grant patent in Europe. The patent or intellectual property protection has to be made by the same country. Okay, so it will give us exclusive right to stop others from making, using, exercising, vending, and importing also. Protection for an invention is granted for limited period. This point is very important. You cannot have monopoly for unlimited time. So various intellectual properties will have protection for limited time. We'll come to that point also. Exchange for disclosing. For what purpose the government is granting monopoly to you? Okay, why government is granting monopoly to you? Because you are disclosing your invention firstly to the government. You are not publishing your invention in newspaper. Okay, if you disclose your invention to the public at large in newspaper, then the novelty of your invention has gone. So that's why you have to disclose first to the government. Here government is patent office or design office. Okay, so right to exclude others from using the invention, that is also important. Owner has qualified right to use the invention. So first Indian patent was granted for the efficient Pankha pulling machine. Okay, and in 1856 in British era. So it was granted to Alfred Deepening, and some of these inventions are there. So you might think that this picture are just a picture of nano or the vaccine or the Jaipur food, but there are multiple intellectual property in that resides in that the picture. Okay, so nano car, more than 100 patents were applied for the nano car. Okay, similarly for hepatitis vaccine, it could fetch. It was just costing 40 cents. So that's why the efficiency was there. Okay, so another Jaipur food, it was available only for $28. So that is also one of the important things. Cost is a very important in intellectual property commercialization. So all these are the though these are the pictures, there might be multiple uh, intellectual properties there inside. So how to file a patent application? Okay, suppose someone want to file a patent application, you need to file a form one. Okay, forms will be always there in government offices. Okay, so government is trying to reduce number of forms. Like they might come down to the two forms only for prosecution or getting patent in your hand, but you have to file a form, whether it is online or offline. Okay, so you need to file form one. What is form one? Details of application and applicants will be there. Form two, details of invention will be there. So form two is very important. It is a complete disclosure of your invention. So there will be a title of your invention, background of your invention, particulars of your drawing. Okay, brief description of drawings, brief description of invention, and claims also. Okay, and abstract drawings will be there. So what is the importance of claim here? What is the importance of claims there? The claims are the boundaries of your property, just like a fence of your heart. Okay, or walls of your uh, house. Okay, these are the important. Okay, so these are very important for infringement also. Okay, so why that's why the patent attorney will charge you more for that claims only, because you have to imagine. Okay, you have just information and you have to imagine how my boundaries is there for my invention. So thereafter you need to file the form 3. Okay, what is form 3? Form 3 is a foreign filing details. Suppose you have also filed foreign application in US, you have filed application, same application, you have filed your application in Japan, then this information must be provided under form 3. Okay, form 5, declaration of inventorship, means what? The institute has filed the patent application. Okay, but inventor cannot be institute. These inventors must be individuals. Okay, so what happens in that case? The institute has to declare. Institute has to give the declaration that these are my inventors. Okay, that's why the form 5 is important. Then thereafter you need to file form 18 also. You have taken admission for the course, but you have not filed the examination form. This cannot happen. You need to file. Intention of getting admission in course is different. Okay, and intention of filing examination form is different for the legal purpose. Okay, so that's why the form 18 is also important. So what is the fees? Fees for patent filing is very less, very less. Form 1 only 1600 requires. Okay, form 2, if your disclosure is up to 30 pages and claims up to 10, no new fees is required. Form 3, there is no fees. Form 18, there is a fees. Okay, form 18 is request for examination. That is 4,000. So these requirements are specifically made for the natural person or the startups. Even your startup is there, you can have the fees. You have to pay the fees equivalent to the individual person. If your company is a small entity, then also you can pay similar fees as to the natural person. If your organization is educational institute, this has been made recently. Okay, if your organization is educational institute, then only you have to pay only equivalent to the natural person. So nowadays, earlier it was only with the government institute, government educational institute. Now it has been made in wider scope. Any institute, any educational institute can apply for the patent. Even school can go for the patenting system. Okay. So, but for the other than the natural person and for the big companies, there will be a higher cost of fees. Okay. So it is 28,000. So you can refer to the Patent Act, patent website. Okay, what happens? You can file your patent application online. No need to come to patent office. Right from the application to the grant of application. No need to come to patent office. In online process, you can go to website like you can create, but in that case, you need to have the digital signature. Okay, you need to have digital signature. So one provisions has been made for early grant of your patent. It is called as expedited examination. Because of that, the patent will be granted in early. Your that process will be expedited. So, who are eligible for that? Startups. Any startups registered with the DIPP. Okay. So now it is DPIIT. Okay. So that startup can also go for early examination. Small entity that also can go for the early examination. Applicant, if applicant is a female, if applicant is a female, jointly or with other natural persons, then also that provision has been made. Reason is that we want to encourage women entrepreneurship. Okay, come up with your ideas and give the jobs for others also. Okay, India as I say, suppose their company or the person has filed a PCT application originally in India, then also that can go for expedited examination. There are single agreement between Japan Patent Office and Indian Patent Office. Okay, so because of that, it is called PPH, Patent Prosecution Highway. Means what? Any Japanese application, if they want to come under PPH, that patent can be also expedited. Okay, to encourage the Japanese investment in India. Okay, it has been specifically made regarding Japan only because of our look east policy. Okay, we don't, as such, I don't know whether the government believes in Western countries or not. You can decide. So that provision also made under the Patent Act. So patent application. What is the processing actually? What happens in the patent office? If you have applied for patent, it will be if it will be as a PCT application, conventional application, or ordinary application. PCT applications means coming through the PCT route, a foreign application in India. Okay. Convention application means filed within the 12 months from foreign country. Okay. Ordinary application means our domestic application. Okay. Normally it is a domestic application. So you can go for the provisional application. Thereafter, you have to file complete specification within 12 months. Then thereafter, from the date of priority, that application will be published. Okay, then there will be the examination, and then there will be objection and examination. In reply to that, you have to give the reply to that comment also. Okay, and thereafter, even though you are not complied, there will be hearing. Okay, based on the hearing, that patent will be granted or rejected. So general screening, actually what happened, many applications will be there in the patent office. Once we receive the patent application, what will happen? Your patent application will be screened and classified. Screening is different and classification will be different. Screening will be done for whether your application is related to atomic energy, whether it is related to the defense purpose. Okay. So if these are related to atomic energy and defense purpose, this application will be referred to respective department for necessary approval. Okay. And after approval, then only your application will be published and thereafter will be allotted for the examination. Okay. Examination is important. Like we are taking admission for the course, but examination is very important. So what is examination actually? Examination is a literature survey. In other words, okay, for anything you used to carry out the literature survey before proceeding for your project work or something like that. You have to carry out the literature survey because of you cannot go directly for the doing your project. You need to carry out your literature survey. Similarly, here also there are formal examination and technical examination. Okay, these are formal examination means what? Whether you have paid fees or not, whether your drawings are in proper format, and technical examination means literature survey, whether similar technologies are already available in market or not. Okay, and then thereafter what happens? The first examination report will be there from the patent office, means objection. Okay, objection will be there from patent office to you. Then you have to comply this objection within 6 months. Again, there may be second examination report. Okay, even though you have not complied that objection, this objection. Okay, so there will be a hearing before the controller, means patent office. Okay, thereafter what? On the basis of hearing, grant or refusal will be there. So what is a technical examination? I have already said that it is a typical literature survey. But literature survey for what? For scientific and technical investigation. Okay, so we will find out whether similar technology is already available in India or not. But it is not. The literature survey will be done on the basis of documents published all over the world. Okay, so this might be non-patent literature. What is non-patent literature? Your research paper, technical research paper. Okay, then thereafter the books. Okay, and patent literature, what happened? Because of publication of respective patent application in respective offices, there will be the database, patent office database, like Indian patent database, US patent database, Japanese patent database, European patent database. So one will examiner or the patent officer will find out and make a literature survey on that published document. Okay, so search related to earlier publication will be there. Check for novelty and inventive step will be there. Prepare detailed report and that report will be sent to you. So what can be patented? Okay, for what purpose you can file a patent? You can file a patent application for composition, any chemical compound or composition, construction or manufacture of substance or an article, and apparatus also. Okay, and industrial type of process also. So you can apply the patent only for this. You cannot apply the patent for discoveries. So what you cannot patent in India? This might be patented in US. This might be patented in other countries. But what is patentable in India? What is not patentable in India? It has been specifically made here. Method of agriculture or horticulture is not patentable in India. Biotech materials as such appearing, okay, in the nature cannot be patented in India as such appearing. I am not saying genetically modified material, okay, that can be patented in India. Okay, medical and surgical and curative therapy or methods and treatment. Treatment of human and animals cannot be. Method or treatment of humans and animals in India cannot be patented in. But in US you can patent. Okay. So computer program per se. Many says that the this is patentable in US, but currently we are giving protection under Copyright Act. That's why the computer program per se is not patentable in India. If you are joining two computer program and instrument together, then only you can file the patent application. Okay. So traditional knowledge. On the basis of traditional knowledge, if you are going to file the patent application, that will not be granted. You can file the patent, but that will not be granted. There will be objection. Okay. So what are these details actually? So what is not again patentable? An invention which is frivolous or which claims anything obviously contrary to well-established natural laws. Okay, uh, we have invented one machine without which gives output without any input. That cannot be possible. Okay, similar kind of apparatus methods are not patentable in India. And inventions, the primary or intended to use commercial exploitation of which could be contrary to public order, okay, against the law, existing law, or morality of which causes serious prejudice to humans, animals, or plant life, or health, or to environment also. This cannot be patentable. For example, a device, apparatus, or machine method for committing theft vulgarly cannot be patented. Any machine or method for counterfeiting the currency notes, this cannot be patented. Okay, similar kind of inventions which are against the law, Indian law, I will say, and morality also will not be patented. Okay, so mere discovery of scientific principle or formulation of an abstract theory or discovery of any living things or non-living things, substances occurring in nature. So discoveries are not patentable in India. Okay, but in US these are patentable. Suppose someone has extracted a cell or a gene which is already there in the nature, that might get patent in US but not in India. So for getting the patent for that gene, you have to modify it. Okay. So mere discoveries of new form of chemical compound cannot be patented in India. What happened there? The Section 3D. This is related to Section 3D. You might be knowing that evergreening of patents. Okay. What happened? US company will file a patent application for one compound. Okay. And it will be granted for 20 years. Again, at the end of 20 years, they will file another patent application for similar compound just by modification of that compound. But there will be no efficacy, only the new form. So similar kind of patents cannot be granted in India. So there are many case laws and litigations in the High Court also and Supreme Court also. Okay, substance obtained by what is not patentable, again, the substance obtained by mere admixture, resulting only in aggregation of the properties of components thereof or process for producing such a substance cannot be patented. Means A product and B product is there. If you are going to mix it and you are getting the same properties which were with the A and B earlier, so that similar compounds cannot be or composition cannot be patented in India. Like I will give one example: two drugs, that is paracetamol and ibuprofen, for curing the fever and pain or process for preparation thereof is not patentable in India. Mere arrangement or rearrangement of or duplication of known device, each functioning independently of one another in known way. Last time I think Godrej has uh, combined the FM radio with the refrigerator. Okay, FM radio with the refrigerator. So the housewife can listen the FM radio at the same time. Okay, while cooking. Normally, refrigerator will in the kitchen only. Okay, so you cannot have the patent for that also. So there are a lot of examples. Okay, you can go in later stage. Method of agriculture or horticulture is not patentable. Okay, but instrument for agriculture can be patented. You only cannot claim the method. You can claim for the apparatus. Okay, for agricultural purpose and horticultural purpose. Any process for medicinal means this is method of treatment of human and animals cannot be patented. Okay, so even what happens, method of treatments are patentable in US but not in India. Okay, but uh, but instrument, diagnostic instrument can be patented in India, but method cannot be patented. So plants and animals in whole or any part thereof, other than microorganisms, but including seeds, varieties, species, and essentially a biological process for production of propagation of plants and animals are not patentable in India. So Plant Varieties Act is already there. So seeds can be protected under that act. Okay. And another is microorganism. If it is genetically modified microorganism, then you can patent that. And plant and animal as such, if someone comes with genetically modified humans, they will not have. Even we have refused E. coli, I think E. coli cell also genetically modified. Okay. So mathematical or business method. This is also one of the important. What is not patentable? We are discussing what is not patentable. Mathematical or business method or computer program per se or algorithms are not patentable. Okay, computer programs are set of instructions for controlling sequence of operation of data processing system. That's why these are not patentable, but these are protectable under the Copyright Act. Okay. So literary, dramatic work, artistic work will not be protected under Patent Act. It will be protected under Copyright Act. Schemes, rules, methods for programming, performing mental acts, and playing games. Method of playing games also is not patentable in India. Like a method of for playing chess, method for method of teaching, method of learning also. These are not patentable in India. But you can claim for the apparatus instrument. Okay. So presentation of information also there. Suppose one has disclosed another method of presentation also, then that cannot be patented in India. Topography of integrated circuits. This is also not patentable because it has been covered. Protection will be granted under Integrated Circuit Act. Invention, which is the effect, is traditional knowledge, or which is an aggregation or duplication of known properties of traditionally known compounds or components, will not have patent in India. In US might be there because we know that one of the best case law, that is turmeric case, it was patented by Indian origin person only in US, but our under the guidance of our chairman, ex-chairman now, Dr. R. A. Mashilkar, it was opposed in the US, and there was a litigation. Okay, because of that, for that litigation, Indian government has to pay a lot of litigation fees to US patent attorney. So that is also there. That's why traditional knowledge are not patentable in India. That's why we have traditional TKDL, traditional knowledge digital library. So it is freely available. You can search any component whether it has been used in India, which texts were used. Even Arabic is there, language. Okay, and many languages, near about 6 languages, that database is there. So TKDL. Why it has been published? Because of to prevent the piracy of our traditional knowledge. Okay. So invention related to atomic energy, these are also not patentable. But if you have the permission from the Department of Atomic Energy, this patent may be granted. Like even Department of Atomic Energy used to file a patent application to Indian Patent Office, and even though we used to send same application to them to clear under the patent act, if they gave approval, then it will be going for examination. Okay. So what are the criteria for grant of patent? So your product or apparatus must be new. You should not appear in any documentation, whether in presentation, whether in the research paper, whether in the slide, or whether in the patent literature or non-patent literature also. Okay, so it should be very new. Patent is granted only when it should be non-obvious, means it should have at least one inventive step, slight improvement. Okay, which that slight improvement should not be obvious. Then only patent will be granted. Third criteria is industrially applicable. Okay, that process or product should be capable of industrially manufacture. Okay, so application was there. One applicant was there, like he has come to us and then he was saying that I have invented one yoga posture. Okay, yoga posture. So no, I want to file the patent application for that. So we say that no, you cannot, because that yoga posture cannot be industrially manufactured. That's why we refuse to grant the patent application for that. So basic, what are the basic timelines? Like suppose you are going, you have just one idea in your mind, you can go for the provisional patent application. Okay, but you need to file the complete specification within 12 months. Means your prototype should be ready within the 12 months. Request for examination, you can file uh, within 48 months from date of priority, means original filing, that will be a provisional application. You have to reply within 6 months to first examination report. You have to file form 3 within 6 months, form 5 within 1 month. You can also withdraw your application. After analysis, even though it is an invented product or invented process, you find that it has no commercial value, then also you can withdraw your application and your fees will be paid back to you. Okay. So hearing submission also, it has to be done within 15 days, and you can oppose. That is also one of the business strategies adopted by many law firms. Like you just oppose any patent application, we'll file the opposition for you. So if any patent application which has been published, you think that it is hampering your business, then also you can oppose that patent application. But before grant, if you are opposing that patent application, it is called as pre-grant opposition, and it has to be filed before the grant. After the grant of patent application also, you can oppose the patent application, but there is a timeline, that is within 1 year from the date of grant, you have to oppose that application. So what is the design? It means industrial design. Design is aesthetic appearance. Okay. So we have earlier taken the picture of the nano. So similar. So term of design is 10 years and it can be extended up to 15 years. Means plus 5. So what is an article? As per the definition of article means any article of manufacture or any substance, artificial or partially natural, and includes any part of article capable of being made and sold separately. Okay, that means it is a definition of article. Original means what? Okay, Taj Mahal is there already, and one has made Taj Mahal shape bottle. Original Taj Mahal is already there, but the bottle in shape of Taj Mahal is new. So for that also you can apply for design. Okay. So these are the some of the articles of the designs. So set of articles. The design can be applied for the set also, like a tea set. Okay. Here is the jewelry set, sofa set. These are some of the examples. So what is happening in the design office? Okay, patent office is different, design office is different. So you can apply online. There is no need to go to design office personally, physically. You can apply your design application online. Okay, and then there will be examination. registration, publication, and post-registration procedure. Okay, if someone want to, even though he want to apply to patent, design application in person, okay, in physical copy, that still available. That facility is still available with us. In some countries, it has been vanished. They have to apply online only. Now it has been made. If you are applying any intellectual property application, and if you are hiring the patent attorney or agent under the act, then that has to be made online only. There is no physical facility. It is only for the individual. So a fees requirement is 1,000 only. Okay. So application form one, like in patent application, all the details will be there of the applicant. Okay. Class will be there. Class number means which field is there, whether it is related to sofa set, whether it is related to tea set. Okay. So these kind of specimen you have to provide while applying for design. Okay. There will be a name, total sheet number. There will be a perspective view of your that product, design product. Okay. So you have to show the novelty also with this statement. Okay. And at the end, there will be a signature and date also. After grant or registration of design, similar kind of certificate will be generated online. Okay. Right from application of your application and generation of certificate, these are all online. No need to come to patent office. Even for the hearing, we used to carry out hearing through video conferencing only. So after grant registration of your design, okay, so that will be published. So this is a format of publication in design journal. Showing your IP is protected, like you can use the registered or RD. So important timelines for ordinary application, that is design is for 10 years, extendable for 5 years. Request for renewal to be filed within 10 years. Okay. Suppose if you want to extend by 5 years, even though if you fail to renew your application within 1 year, you can again renew. Okay. So what is trademarks? A trademark, a concept, a trademark is any word, name, symbol, or device, or any combination thereof. I have taken literally from the definitions of the act. Okay, you can ask me in between. So function of provides the exclusive monopoly. What is the function of the trademark? It provides the exclusive monopoly over a class of goods. Okay, or the services. You might be knowing that Amul is a dairy products also, and the garments also. Okay, so why Amul is a garment and dairy product? Because they have different class. Okay, they are not a food product. uh, Amul is for the garments, and another Amul is for the dairy products. So another, it allows the business entity to build a public goodwill and brand reputation. Okay, some products we know that Apple, it must be a very good product. Okay, some the Samsung, in refrigerator might be some specific product. In the air conditioning, Hitachi. Okay, we know that they have reputation because they have multiple patents also, multiple invention for that product also. Okay, so it identifies the source and origin of the services. Basically, it identifies from which company it is coming. Okay, it assures the customer about the quality of goods and services also. So these are the some of the examples. Like in trademarks, we have service marks, trade names, collective marks, certification marks, tagline and slogans also can be trademark registered as a trademark. Shapes and sounds also. So what is a good trademark? It should be inherent. It should be acquired. Okay. It should not be deceptively similar. It is very important. Deceptively similar. I think there was one uh, entrepreneurship program on the Sony News. Okay, so pardon, Shark Tank, yeah, Indian Shark Tank. Okay, so one inventor or the manufacturer has made the accessories related to the roadies actually. Okay, that two wheelers and three wheelers accessories. So these were similar to the accessories of the one of the best known company. So it was actually refused by to fund for that product also because of these were deceptively similar. Okay, so you might, even though you have filed the trademark application, but if these are confusing that similarity in the mind of the consumer, then also you may not have the funding from the investor. Okay, so registered unregistered trademark, if is there, then they can use it TM sign. Okay, if it is registered, they can use R mark. Okay, how to protect your trademark? Trademark registration is optional. It is also optional. Okay, but you have to show the use of your trademark. More the timeline, better the chances of grant of your trademark registration. So registration available at national, regional level and international level. Initially registered for 10 years and it can extend indefinitely in 10 years time. Okay. So in case of non-use and non-renewal, if there is no policing, trademark rights will be lost. If you are not using any trademark, then eventually that trademark will rights will be lost in that trademark. Existing trademark registration is governed by the Act 99 Act. You can go to ipindia.gov.in for more information. So what is a copyright? Are you interested in copyright? Copyright is very important. Still, I am taking that uh, this small. I will skip some slide if you want. Okay, copyright is a bundle of rights. I have already said that with any intellectual property, you will be having bundle of rights. Okay, so it is a bundle of rights. Automatic rights. Automatic rights means what? You don't need to go for registration. If you have written any book, from date of publication of that creation of book, your right will be created. So only problem will be there if you want, if someone has copied your copyrighted material or only created material. If you want to go in court of law, before that you have to register. Okay, so your right will be created from the date of creation of that copyright. It allows to it allows the owner to choose how it will be made publicly available. Suppose you can decide. Suppose you have written one book, okay, originally, you can choose how it should be made available to public, whether it will be in short copy or in hard copy. Okay, either in public announcement like broadcasting also. Okay, prevent it prevent unauthorized copying and reproduction. So under section 2Y, it defines what is work. Okay, so there are a lot of definition. If someone is really interested in copyright, they can go and read the Copyright Act and manual also. Okay, so it should have creativity. Then only it can be, it should be original. Okay, it should be uh, it should have some creativity. It should have originality, and it should have fixation. Fixation means what? It should be transported into tangible form. Though it is intangible, it should be transported into tangible form, like book or the script. Okay, in written form. Then only it can be considered for copyright. So features of copyright, these are some of the sections where if you, uh, what is the administrative function of the copyright office, these have been covered under chapter 210. Some of the provisions, how to license your copyright. Okay, how to license your copyright. These have been covered under chapter 6 and chapter 6 to 10. Provisions related to ownership, these have been covered under chapter 4. Okay, broadcasting related provisions, these have been covered under chapter 8. Provisions related to the remedies are infringement and remedies. If someone has copied your copyrighted material, then which type of remedies will be there with you? These all provisions are there under chapter 11. So section wise, like you can have the copyright for the literary work like books, then dramatic work, okay, uh, then thereafter the sound recording work, it will be covered under section 220, okay, and musical work and artistic work. So who are these authors for specific work? For literary or dramatic work, the original owner will be known as author, okay. So for musical work, the music composer will be owner, okay. Artistic work, other than photograph, artist will be there, he will be the owner. Photograph, the photographer who takes the photograph first will be the owner. And for the films and sound recording, the producer will be owner. Literary, dramatic, musical, artistic work, which is computer generated. Nowadays, many programs are there which can create the music also. Okay. So who is the actual owner? So actual owner will be the person who caused the work to be created. He will be the owner. Means the person who has written the software and utilized that software for creation of that sound or music. He will be the owner. So there are two types of rights. Actually, you can say that the economic rights and moral rights. So economic rights are transferable. Okay, economic rights are transferable from one person to another, but moral rights are not transferable. Okay, you have to mention the original creator. So the scope of economic rights will be there. So reproduction rights will be there, distribution rights will be there for economic rights. Right to create derivative works also will be there. Right to communicate to public will be also with the economic right. Right to public performance will be also with the economic right. But scope of moral rights will be very limited. The original creator will have right against the distortion also. Okay, integrity. So right to recognition means someone has copied your copyrighted material. Even that copy uh, infringed or copyrighted or copied material will original author can claim that it has been created and my name should be there. Okay. So term of protection, it has been mentioned for different copyrighted section like a published literary dramatic work. It is the life of author plus 60 years. Okay. The films and sound recording 60 years from date of publication, broadcasting rights, reproduction rights 25 years, performance rights up to 50 years. So application procedure same. You need to file, if you are dealing with the government office, you need to file at least 1 2 form. Okay, 1 or 2 form. So form will be there, 14 number form. Every such application can be filed in the copyright office by person or by e-filing also. Payment can be made in form of payments and gateway. Payment gateway. Okay, online you can file and pay the fees also. So very less fees for the like literary dramatic work, musical work 500, artistic work 2000, sound recording 2000, and films, and that is 5000 rupees. So what is happening in the Copyright Office. Okay. So once the application has been received by Copyright Office, so formality checkup will be there. Okay. There will be some waiting period. There will be scrutiny of your application, and if any lacuna is there, then the intimation letter will be issued to the applicant. Thereafter, what will happen if there is no response from the applicant? Eventually, that application will be abandoned. If you have that lacuna has been rectified by you, then there will be um, approved by the registrar. If there is a, even though there is a lacuna, if registrar of copyright think that there is a again lacuna, he will call you for the hearing. Nowadays hearing is online through video conference. Okay, so that will be there, and if yes, then your registration will be approved. Okay, so Semiconductor Act, nowadays you use many gadgets. Okay, like you're in mobile is like a computer for you. An actual computer is this. Okay, same function can be done by the your mobile also. So but what is there inside? There are a lot of integrated circuits. Okay, this has to be covered under the, and this has to be covered protected under the uh, integrated circuit act. So Semiconductor and integrated circuit acts main function is that to protect the integrated circuit of any any device. Okay, any device is there. That is the main function. Registration layout is protection is granted for 10 years. Okay, so this is a procedure actually for the application. Same flow chart will be there, like a publication, objection, objection communication, then your comment. If you are going to rectify it, then it's okay. Then there will be hearing, because these are the procedures. They cannot simply reject your application. Okay, unless until you have been heard. Okay, if you have not been heard and your patent any application for IP protection is rejected, then say that the court will hang these officers normally. Okay, so that is also there. That's why hearing is must if the any officer is rejecting your application. So geographical indication, you might be. I have just received the momentum, that is Warley painting. So that is covered under GI, and it is owned by one of the association of tribal community and government of Maharashtra, jointly owned. So okay, so association is necessary. Single person cannot own the GI. I will take one example also for that. So these are the examples of the GI, geographical indications, like a Darjeeling tea, Nagpur orange. Okay, this might be related to natural resources also, or artificially manufactured also. Okay, so Darjeeling tea, Ratlamil save, Kanchipuram silk, these are all protected under GI. And some of you might be interested in Kadaknak also. Kadaknak, you might be knowing. Okay, it's a chicken from specific district of Jhabua. Okay, and the GI for that is owned by specifically government of Madhya Pradesh and Chhattisgarh also. So in Maharashtra, if these people, some people are selling that any product saying that it is a Kadaknak, that is illegal. Okay, that is illegal, and government of Madhya Pradesh or Chhattisgarh can take to court of law. So we have Warli painting. Okay, so that is Katputlis of Rajasthan also. These are all covered under the Geographical Indication Act. Natural resources, Magi palm, Devastali pomelo, Alpimedi mango, okay, Kurk orange, Shahi lychee of Bihar, Kashmiri saffron, these are all protected under GI, and basmati rice, that also protected under GI. Okay. Now I think there is a litigation between Pakistan and India. Okay. So IP is everywhere. So I will just conclude. Patent is granted for 20 years. Okay. Design is granted for 10 years plus 5 years you can extend. GI mark indefinitely. Okay. By repeated renewal by 10 years. Okay. GI is also GI is also granted for indefinite time. Okay. But it is granted initially for 10 years. Copyright, it depends on the actual copyrighted material. Okay. Who can apply? Person, individual, a person or a legal representative, or person includes firm, partnership, small entity, and body incorporate, and government also. Person includes government also, because if government want to have the patent or any IP protected, I have given an example of the Department of Atomic Energy. Even though they have the invention, they have to apply to the patent office. Even for GI, the government of Madhya Pradesh and Chhattisgarh, they have to apply for the GI protection. Okay, even though they are government. So that's why it is important for academic purpose. We see you as a very at a grassroots level, but you are going to industry. Okay, so that sense must be generated in your mind to generate intellectual property and protect intellectual property. That's why we say that first to protect, then publish. Okay, first protect, first file the application, then publish it. But in case of copyright, it is not so. It will be automatically generated. Okay, even in trademark also. So registration is done by sovereign authority, means government of India, right, for limited period only. No automatic relief. Okay. So suppose someone has infringed your right, someone has copied your invention, you have to go to court of law. Okay. So the government is in process to have the IP enforcement agency also. Okay, they are in the process, but it will take some time. But right now, the actual uh, relief can be given only by the court of law. So renewal fees has to be paid. Okay, for protection of IP. So opportunities, where you can have opportunities. You can work as an examiner of patents and design if you have scientific and technical qualification. You can work as an examiner of trademarks. Any law degree holder can work. Okay, examiner of copyrights also. Other private fields are patent agent. You can work as a patent agent, patent specialist. You can work as a trademark agent also, and many patent facilitating centers are all over the India. So you can work as a JRF, SRF also. Now we need a technology manager also. Okay, technology manager. Creation of IP is different, and managing that IP is different. Okay, so we need a technology manager also, and then petty litigation and other opportunities are there in private sector. So in many big companies there, like in Reliance or in Tata, there will be a huge manpower for IP protection, their own internal. Okay, even though they are hiring the patent law firm from only for the prosecution, but internally they have very big manpower for IP protection. Okay, I have seen the small companies in the Canada, even it is a small company, they will be having near about 20 to 50 people as a specifically for IP protection inside their company. Okay, so these are there. So you can contact to our IG and IPM for more information. So I will quit that quiz part. Now you can ask me question. Any question? Yeah. Okay, you can go. Suppose we consider the patent. Suppose we consider the patent. Okay, there are two, three routes for applying patent. Being a Indian, okay, Indian citizen, you can apply. You can choose your patent office as a first filing patent office. Okay, first filing office. In by taking that priority, you can file your patent application in US and Europe also. Europe is actually with the multiple countries. Okay, so there also, but
So we have no limitation to how many countries we want to apply.
there are no limitations. Suppose actually what happened, there is a PCT route also. PCT route means you are filing your application through PCT route in India. There will be an automatic examination report whether the examination report will give you report regarding the patentability, whether that patent will be granted or refused. Based on that report, you can have 31 months from initial date of filing to enter in each country. Because I have already said that the patent protection is territorial. Patent is granted for territorial. Okay, it is territorial right. Territorial right. So it cannot be like there is nothing like the world patent. Okay, in each country you have to go and apply for the same process. But in that case, what happened? The we have PPS with Japan. Okay, so any Japanese applicant or company can come to their taking their patent application in India, and then it can be granted earlier. Similarly, we have provision that if you want to do the business in the Japan, then also you can take your patent application directly to the Japan, and then you can have patent there based on the Indian findings.
And so, what are the education qualifications required for to be an examiner for patent or design?
So I have already said that most of the in the patent office nowadays we have the officers uh, having qualification from the IITs, IISc also, and most of these are the MTechs and PhD science. I think some of the student from the Ruya College also he was posted earlier somewhere. So there are for to be a patent examiner, you have to be scientific qualification. So even there is a basic limit like masters in science or BTech in or engineering in the undergraduate qualification.
Thank you, sir.
Yeah.
Hello. Yeah, initially, first of all, thank you so much, sir, for the detailed insight about IPR. Like, my question is, I just wonder, considering the real-time scenario, like, for example, Apple company, if we consider, spending millions of dollars every year for this, just for designing of the new cell phone, and we see within couple of days it get copied in China, and like lots of car designs of Mercedes, BMW, it's been within few days it is being sold under a new brand in China. So right now, I just wonder how this kind of current real-time scenarios is getting tackled by these big companies.
Okay, actually they will be having a big manpower for IP protection. Okay, I have already said that they are spending near about 70% of their total funds for product generation. Okay, it includes the IP protection also, and only 20% of the manpower. So because of that, they can manage to file the patent in a single day at a multiple countries. Okay, they can manage. So, but protection in the China is something is difficult. Okay, litigations. Even though they have very good system, like mm, I think I had information that they have created the post like IP enforcement officer for each district. And if he says that it is pirated, it is copied, then that product will be confiscated. Okay, so it will be captured. That product will be captured and retained by the that officer. So similar kind of facility may be there in India also in some days. So big companies spend more on the IP protection also. That is the reason. But at least we, as an academics, we can just start by generating IP and trying that, taking that product, patented product or copyrighted material to public at large. That can we make. Okay.
Thank you, sir.
Yeah, good evening, sir.
Yeah.
Whenever we see any reports on worldwide patent filings, we notice that India is pretty down in the numbers. US, China, and Israel normally dominate the numbers. Now, one of the things that you've been saying is that there are a lot of areas in which a patent cannot be filed in India, but it can be filed in the US. So, is there any particular reason why that is the case?
I think.
And is that a possible reason for the low numbers?
No. Actually, what happened? I already covered that point. Recently, because of patent awareness program, okay, in the academic institutes and educational institute, the first time we have surpassed the domestic filing. Okay, so last year it was like 40,000 patent application filed by the foreign companies or foreign national in India. Now we have 60,000 patent application filed by our own people and own companies. So that is amazing. But actually, what happened? The in Japan, it is somewhat very big. Like only 1 lakh application will be filed by foreign companies in Japan, and near about 3 to 4 lakh patent application will be filed by their own people, own companies, Japanese companies. Okay, for minor improvement, continuous improvement. Okay, so that culture is not here in India. Okay, for any improvement, if you are going to file, okay, that number can be increased. Even though government is trying nowadays, we have made many facilities to filing patent, protect, and also for protecting your intellectual property. So I think that is a case of like difference between developed countries and developing countries. Okay, so patent can be used as a barometer. Patent can be used as a barometer for development, whether that country is developing or developed. So in our case, we are still developing. So that's why the number might be low because of that. And I have already covered that part. What are the lacunas with the academic institute? Because many inventions done in the industry, but you can find the origin for that invention in academics only. Okay, academics only. The main origin is academics. So we need to strengthen our academics for IP protection. And then I think government has lately realized actually the IP protection chapters will be there in NCERT syllabus. How to protect intellectual property? What is intellectual property? Similar kind of information will be there in NCERT syllabus. NCERT. Okay. So I think still we don't have the IPR as a full subject. So that is a lacuna. So we need to analyze that situation also.
Thank you, sir.
Thank you.
Okay. Uh, Thank you so much. And thanks for all the questions which were asked. It was a very interesting, invigorating session. And thank you so much, sir, for taking us through this process, end to end process from patent filing to patent grant. And you did it in 2 hours flat. I'm sure it has triggered a lot of questions in our students' mind and it will help bolster IPR awareness in our institute, and this is going to have implications at the national level also. Thank you so much, sir. And we thank AICT and NIPIM and DPIIT for helping us jointly collaborating with us in conducting the session. Thank you so much. Thanks, everyone. It's time. ठीक है. So we will remove these. We will remove.
It's a keep and
Okay.
these are all information publicly available.
Okay, publicly available. Oh, very nice.
Slides are available.
Okay.
All the various officers are actually deputed for only IP awareness.
Okay.
We think that because of that, more patents have been filed.
Okay. Definitely, sir.
Yeah.
Entire spectrum, yes, sir. Yes, sir.